All right, back for another weekly recap. A day early this week. This probably is the last weekly recap because there's not going to be a whole lot to talk about after this until the jury comes back with a verdict, which isn't expected until sometime next week. But in the meantime, while they're deliberating, we don't get to see their deliberations. They happen in secret. So there's not going to be a lot to talk about until they come back with the verdict. And I'm going to, at the end of this little video clip, talk about and make some predictions about what may happen with the jury and their deliberations and what the ultimate verdict, in all likelihood, in my opinion, will be. But before we go there, let's talk a little bit about the week. The defense rested and the government put on its rebuttal case, called 4 or 5 witnesses that offered fairly small bits of testimony and evidence in an attempt to rebut the defense case. Overall, the government called 43 witnesses. The defense called, as I understand, 25 witnesses. One of the big issues here towards the end of the trial has been the involvement of government informants, confidential government informants, and agents provocateur, many of which have not been disclosed. So at this point, we have no idea who some of those people were and what their role was and what kind of evidence they may or may not have been manufacturing. But the reality is all of those things can create reasonable doubt that the jury can look at in terms of determining what they think actually happened. After the rebuttal case, then the government made its closing arguments. Those observers who were there and observed the government's arguments, their consensus seemed to be that the government's closing arguments were fairly weak. It took about 2 hours, hour and a half, 2 hours to do that. And then Marcus Mumford arguing for Ammon Bundy took all afternoon, 4+ hours, to make his closing arguments. And a lot of people, observers at the trial, said that despite some other struggles perhaps with evidence and arguments with Judge Brown from time to time, and perhaps some disorganization here and there, that Attorney Mumford was really in his element and at his prime in his closing argument and made very strong arguments on behalf of Ammon Bundy and all the defendants in the case. Ryan Bundy made his own closing arguments. He represented himself, making his own closing argument, and then most of the other arguments were made by attorneys for the other defendants. The attorney who court observers have said really hit a grand slam and knocked it out of the park was Matt Schindler, who represents Kenneth Medenbach. But one of the interesting things that Matt Schindler said was that the government has accused these defendants in this case of impeding federal officers by force, intimidation, or threats. And what he said was that during the course of this trial, the government has not been able to produce any evidence of any threats. They have not really been able to produce any evidence of any actual force. Then the question comes down to intimidation. And one of the things he pointed out is that many of the decisions that were made with respect to whether or not the employees should continue to work at the refuge or at the BLM office during the occupation were made before the occupation even started, before the decision had even been made by these defendants to have any kind of an occupation. So then there's all kinds of evidence with respect to this issue of intimidation. What does it take to intimidate? What is reasonable intimidation? And one of the points he made was that in contrast to what was going on at the wildlife refuge, just to go into the courthouse in downtown Portland, the federal courthouse, which is surrounded by multiple armed, legions of armed Department of Homeland Security officers, decked out in full battle rattle, fully armed, multiple security checks. He said, now this is where the real intimidation is occurring. This is where the real force is occurring. This is where the real threats are occurring. And he drew that contrast between what had actually happened at the refuge. And he made a number of other very interesting points. But one of the points he made was this, that he's been practicing in federal court in Portland for 20 years. And this is the first case in which he had a defendant or dealt with any defendants who said anything or cared anything about God, or that God was any part of the discussion, or spirituality, or prayer, or anything like that. But the even more important point was, he said that in 20 years, he'd never dealt with another case that even cared about or discussed or attempted to discuss the Constitution of the United States. And what's interesting about that, and as we go back and look at the closing arguments, a number of the attorneys and a number of the defendants, including Ryan Bundy, attempted to quote from the Constitution of the United States. And in every instance, an objection was made, which is very rare in closing arguments. Attorneys typically object to admission of evidence. During closing arguments, everything is pretty much fair game. Objections are supposed to be kept to a minimum, only used in rare and extreme circumstances. But in this case, every time any of the attorneys or Ryan Bundy made any attempt to refer to the Constitution, an objection was made and sustained by Judge Brown. Throughout the course of the trial, she did not allow the defendants to ever talk about or to ever quote from the Constitution of the United States. And I find this very ironic. We've written about this on Rangefire. We have a series, a multi-part series that we talk about the 7 realities in the West and in this nation that nobody wants to talk about. And a lot of these are very ironic realities, but one of the very first and one of the most ironic is that in this country, where Judge Brown herself and all elected officials and every one of the jurors and every one of the alternate jurors were required to take an oath to uphold the Constitution of the United States, in the trial, nobody can talk about the Constitution. Nobody can talk about what the Constitution means, or attempt to determine whether anyone has any kind of understanding about the Constitution and what it means and how it applies to a case like this. And so I find that to be a true irony in this country at this point and in this case. So and I haven't been there this week, but according to those who have been, they said the real turning point, and a lot of people were really concerned and have been from the outset about where this case would go. And a lot of people have talked about, and so have I, about the obvious biases of Judge Brown. But of course, Judge Brown is trying the case. She's the referee, but it's actually the jury that decides the case and enters the verdict in the case. So regardless of what she may think, or regardless of how she may call the evidentiary rulings and all of those things, ultimately it's up to the jury to decide guilt or innocence in the case. And what a lot of people have said is that the real turning point in this case, probably, in terms of momentum, in terms of the direction this case was going, was when Ammon Bundy took the stand. And he was on the witness stand for part of 3 days. He testified for a long time, and he just laid it out there. He didn't try to hide anything. He just told it like it was. There wasn't really even much to cross-examine him about when he was done. The government only cross-examined him for less than 20 minutes because he just laid it out there. He stuck his neck completely out. He explained what he was doing, why he was doing it, why he was there. And a lot of people think that in some way he made admissions. The government said their very admission that they were there to stake an adverse possession claim supports the concept that they were engaged in some kind of conspiracy to impede or interfere with federal officers. But the reality is A lot of people have said that it actually had the opposite effect, that that was the turning point and the momentum started going the other direction in the case, regardless of Judge Brown's rulings. And it was while he was testifying that a lot of that became more painfully obvious in terms of her biases as she engaged in a number of evidentiary rulings, including a number of inconsistent evidentiary rulings. At this point, the jury has the case. They have the evidence. They will deliberate as long as they feel like they need to reach a verdict. There are three possibilities. Either they will convict the defendants, and they don't have to convict all the defendants. There is a verdict form for each individual defendant. So they could convict some and acquit others. So that's one possibility, conviction. The other possibility is acquittal. The thing that people need to understand is that to convict or to acquit, the jury has to be unanimous. All 12 of the juries that are seated for the deliberation need to be unanimous about a decision to convict or acquit. My prediction in the case is this, that there will never be a unanimous jury in this case. I predict that it will end in a hung trial. I think that there are probably people on that panel, that jury panel, that would not be willing to acquit these defendants, or at least all of them, no matter what. No matter what the evidence was, no matter what some of the other jurors thought or anything else, I seriously doubt that some of those jurors would ever be willing to acquit these defendants. On the other hand, there may be some on the jury who feel the same way with respect to conviction, that regardless of the evidence or the arguments or anything else, they would not be willing to vote to convict all of the defendants in the case, or even part of the defendants in the case. I don't know that for sure, it's just a prediction, but there has to be a unanimous verdict to convict or acquit. And the reality is we've reached a point in this country where we're so polarized. And I think that this jury, and a lot of people have said that this case is being tried in Portland, which some people consider to be the bastion of socialist, of basically liberal social environmentalism. In other words, Portland is the place in this country where you could get a conviction on this, in this case, against these defendants easier than you could anywhere else in the country. And so if you're not able to secure a conviction here, where could you secure a conviction? Now, if the case ends in a hung trial, then the government has to decide what it wants to do at that point. Does it want to start over from scratch and attempt to retry the case? There's another case with other defendants scheduled for trial in February in Oregon. Plus, there's another federal case involving the Bunkerville standoff in Nevada, likewise in February. If the government decides under those circumstances that it wants to attempt to retry the case, then it throws the whole schedule completely out of kilter. And so those are some factors that will have to be taken into consideration. But I think that there's a good chance that that's what's going to happen. And I think that if that does happen, that's something that we're going to have to really look seriously at in terms of what is the likelihood that the government could secure convictions against these defendants at any point in another trial. Again, the evidence, the admissible evidence remains the same. The basic facts remain the same. It doesn't appear to me that they can do anything to make their case a whole lot better than it is and that they have presented. They did a good job presenting the case, the evidence that they had. The problem was the evidence was very marginal and the defendants were able to put on a good case. They may be able to put on a better case the next round. They had a lot more witnesses. They had a lot more evidence that they wanted to put on. If that's the route the government ends up wanting to go, then we'll just have to roll the dice and see what happens at that point.